Um, okay, so Ms. Dugas is on probation for the offense of robbery, a second-degree felony. We were previously here, and she entered pleas of true to counts 1 through 12, all of the counts in that motion, second amended motion to revoke unadjudicated probation. I received the updated pre-sentence report as well as a letter from Ms. Dugas. Has everyone had an opportunity to review that? Are there any additions or corrections?
None from the defense, Your Honor. No,
All right, and this was unagreed, correct? Ms. Holmes, you may proceed.
Thank you, Your Honor. I've spoken with Ms. Dugas. Obviously, the various new offenses and violations is not acceptable through probation. She understands that. She stated that throughout this time, she did not have much support. She was going through a hard time in life, and she resorted to doing and committing these offenses. Not being in obviously the right state of mind to be able to successfully complete probation. Ultimately, Ms. Dugas is requesting to have the opportunity to be reinstated to complete probation, and she would like to address the court in regards to this as to her plan of how she can successfully complete if given the opportunity.
Here's what stands out to me. She's asking for another chance. And in isolation, that sounds reasonable. People struggle. People relapse. People fall apart. But probation is already the second chance. When a judge hears, I just need one more opportunity, what they're really evaluating is, did you learn from the first one?
Ms. Dugas, you did the exact same thing. You robbed someone else while you're on probation for robbery. Not just robbed someone else. You failed to ID, failed to report to probation. You committed the new offense of possession of a controlled substance. You resisted arrest it's ridiculous to me that you're saying you want a second chance because this was your second chance. You've already been on probation. You were given the second chance of not going to prison. The fact that Ms. Holmes negotiated a cap of 8 years for you, you should thank your lucky stars. This is ridiculous. 8 years, in my opinion, is not enough. You had every opportunity to do all the things that you're taught. Stop crying because you weren't crying when you were robbing people and using drugs and not being a good mom and not doing the things that you should have done when you were given this opportunity.
That shift in tone is powerful. When a judge says, stop crying, it sounds harsh. But what she's reacting to isn't emotion, it's repetition. Robbery, while on probation for robbery. From the court's perspective, that's not a mistake. That's a pattern. And courts punish patterns more severely than one-time lapses.
Ms. Dugas, I'm going to find that you entered your pleas of true to counts 1 through 12 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of robbery. Going to sentence you to a term of 8 years in the Institutional Division of the Texas Department of Corrections.
8 years. Notice something. The judge even says it's not enough in her opinion. That tells you how frustrated the court is. Probation is mercy. Prison is consequence. And when mercy doesn't work, the tone changes.
Good morning. Are you Wesley Antoine? And Mr. Antoine is here for sentencing on probation, a deferred probation for aggravated assault, family violence. And that was a 10-year deferred probation that he was given back November 14th of 2023. Entered pleas of true, it looks like, to counts 1 through 11. In the motion to revoke unadjudicated probation. I've received an updated pre-sentence report. This was an open plea to the court. Is that correct?
Yes, Your Honor. The court had previously, when we were here before, it advised the court, that he received 4 months on that new case in Louisiana, but it does involve the same victim misread as his case here.
Mm-hmm.
We had discussed 6. The court did not feel comfortable with that, so we just decided to go on to you.
Okay. All right. So that's what, and I wanted to remind myself, I had a notation on this about that new offense. So the new offense was in Louisiana, and it was domestic abuse, battery, also by strangulation, correct?
And then the courtroom shifts from theft and probation violations to violence inside a relationship. The emotional weight here is completely different.
So on that original pre-sentence report, and the orders that went along with that, I mean, this is a first-degree felony. So on that deferred probation, it specifically ordered all the things that Mr. Lewis is asking for now. You've already had access to all of those things. To be placed on the specialized mental health caseload, to get an evaluation and get any type of help and treatment that is available. You were ordered to do those things. And in fact, what you pled to on this motion, true, is that you didn't get the evaluation completed. And so you never were able to get services. And that was your choice.
This is important legally. Mental health mitigation only works when someone actually tries to use the resources offered. The court ordered evaluations, specialized caseload, treatment access, and he didn't complete it. When help is offered and refused, sympathy shrinks fast.
I mean, the allegations in this underlying case is that you had a cane and that you just beat the crap out of Miss Red with that cane while she's on the ground. And then you get out and you get around her again and you strangle her.
There's no dramatic yelling here, no theatrics, just a judge calmly laying out what happened. And sometimes calm descriptions hit harder than shouting. Domestic violence cases are taken seriously, especially when it repeats with the same victim. That's where courts draw a hard line.
I'm going to find that you entered your pleas of true to counts 1 through 11 freely and voluntarily. I'm going to find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault on a family victim. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the laws give you the right to receive. I believe the initial was yes. I am going to make the finding that there was a deadly weapon in that initial case. I'm going to hand you the trial court certification. You need to sign this with Mr. Lewis. It shows that this was not a plea agreement. You have some rights to appeal. You can talk to him about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Lewis. Good luck to you, sir. Sign that, and then you can go back with the bailiff.
15 years and a deadly weapon finding. That changes everything. Parole eligibility, future consequences, even how future charges are treated. When probation is violated in violent cases, the court's message is clear. You had your opportunity. Now, public safety comes first.